You are driving down the highway. Legal speed. All your documents in order. Out of nowhere, lights flash in your mirror. You pull over. You answer the officer's questions. You sign whatever he puts in front of you. You drive away thinking you handled it perfectly. You did not. That stop just handed law enforcement everything they need to take your license, your money, and possibly your freedom. Before we get into it, if you are the kind of person who wants to know your rights before you ever need them, subscribe to this channel right now. We break down real case law, real rulings, and real protections most people never learn until it is too late. Hit that subscribe button and turn on notifications so you never miss a video. Now let us get into it. Here is what nobody tells you about a traffic stop. The moment those lights come on behind you, a legal clock starts ticking. Every word you say, every movement you make, and every question you answer is being recorded, evaluated, and potentially used against you. Not because the officer is corrupt, but because of 5 Supreme Court rulings that rewrote the rules of every traffic stop in America, and most drivers have never heard of a single one. I have spent years going through traffic stop case law, reviewing hundreds of documented encounters, and studying the exact moments where ordinary, law-abiding drivers handed over their constitutional rights without even realizing it. 5 rulings come up over and over again. Drivers who did everything they thought was right and still lost. Today I am walking you through all 5 with the exact language you need at every stage of a stop. Let us start with the most misunderstood ruling of all. The silence trap. Here is the mistake. A man answers police questions voluntarily. No arrest, no Miranda warning. He answers freely for a stretch of time. Then the officer asks one specific question about a weapon. The man goes quiet. He says nothing. He thinks his silence is protecting him. At trial, the prosecutor stands in front of the jury and tells them that silence was evidence of guilt. The attorney objects. The court overrules it. The Supreme Court upholds the conviction 5-4. That case is Salinas v. Texas, decided in 2013. Genevieve Salinas walked into a police station voluntarily, not under arrest, and answered questions until the officer asked whether shotgun shells from a crime scene would match his gun. He went silent. Said nothing. The Supreme Court ruled that staying silent is not enough. You have to say the words out loud. Without them, your silence becomes evidence against you. Picture this. The officer asks where you are coming from. You answer. He asks if you have had anything to drink. You say no. He asks if there is anything in the car you should tell him about. You pause for 2 seconds. That pause is captured on the body cam. It can follow you into a courtroom. The correct move the moment an officer goes beyond asking for your license and registration is this: I invoke my Fifth Amendment right to remain silent. Not a pause. Not a shrug. Not I would rather not answer that. Those 5 specific words create the legal protection. Without them, Salinas says your silence is ammunition the prosecution can use against you. Officer asks where you are headed tonight. You say, I invoke my Fifth Amendment right to remain silent. Officer says that seems suspicious. You say, I invoke my Fifth Amendment right to remain silent. Officer pushes harder. You say it again. Calm. Polite. Exact. The moment those words are on the body cam, your silence is protected. Without them, it is not. Bottom line, silence alone is not a Fifth Amendment invocation. The words are. Say them every time. Now you know about Salinas. But what if the stop itself should never have happened? What if the officer had the law completely wrong? The second ruling answers that, and the court did not side with drivers. The officer's mistake. Here is the scenario. You are driving in North Carolina. One of your brake lights is out, North Carolina law only requires one working brake light. You are completely legal. An officer pulls you over anyway because he believes both must work. He is wrong about the law. During that stop, he finds something. You assume any evidence gets thrown out because the stop was based on a legal error. The Supreme Court ruled 8-1 against you. That case is Heian versus North Carolina, decided in 2014. The officer's misreading of the statute was considered objectively reasonable, meaning a well-trained officer could have interpreted the law the same way. Stop stands. Evidence admissible. Conviction upheld. What this means is that citizens cannot claim ignorance of the law as a defense. Police can. You forget your registration. That is your problem entirely. An officer misreads a vehicle code and stops you for something that was not actually illegal, and if his misreading was reasonable, that stop is constitutional. Do not argue statute numbers at the window. That is not where you win. That argument belongs in a motion to suppress, where an attorney examines whether the officer's legal interpretation was genuinely reasonable under the circumstances. Challenge the law in court. Not at the window. Bottom line, a legally incorrect stop can still hold up constitutionally if a reasonable officer would have made the same mistake. Now you know a stop based on an officer's legal error can stand. But once that stop is happening, what rights do you actually have from the first question the officer asks? The third ruling covers this exactly. The roadside interrogation. Here is the mistake. You get pulled over for weaving. The officer walks up and starts asking questions. Nobody has read you your rights. You answer everything because you are not under arrest. You believe Miranda only kicks in once you are in handcuffs. You are wrong. That case is Birkmare versus McCarty, decided in 1984. A driver stopped for weaving admitted roadside to drinking beer and smoking marijuana before anyone read him his rights. He was convicted. The Supreme Court ruled traffic stops are not custodial interrogation. Officers do not have to Mirandize you before asking questions at a stop. But Birkmare established something important. Your Fifth Amendment right applies from the very first question at any stop. You are not required to answer anything beyond presenting your identifying documents. Picture this. It is 2 a.m. You are outside your car. The officer is friendly, conversational. He asks if you have had anything to drink tonight. You say just 1 beer, about 3 hours ago with dinner. He asks where you were having dinner. You tell him. You just placed yourself at a location where alcohol was present, confirmed you consumed it, and gave him a timeline he can test against the stop data. You were being honest. All of it is now evidence. That is the trap Birkmare sets. You did not lie. You just built the prosecution's case for them. The correct move: hand over your license, registration, and proof of insurance. Beyond that, I invoke my right to remain silent. Cooperation does not mean conversation. And if this kind of constitutional breakdown is helping you understand what your rights actually look like in practice, subscribe to this channel right now, because the next video I am releasing covers how these exact rulings stack against each other during a single stop. You do not want to miss it. Bottom line, your Fifth Amendment rights are active from the first question at any traffic stop, not from the moment of arrest. Now you know your rights during the stop. But what about the moment right after? Ticket written. Documents back in your hand. The officer is not letting you leave. The fourth ruling is the one that catches people who think it is already over. The stopwatch rule. Here is the mistake. You were stopped for a lane violation. The officer checks everything, runs your license, writes a warning, hands it back, then casually asks if you mind waiting just a few minutes. You say sure, no problem. 7 minutes later, a drug detection dog arrives and alerts on your car. Your vehicle is searched. You handed over those 7 minutes voluntarily. You did not have to. That case is Rodriguez versus United States, decided in 2015. Officer Struble stopped Dennis Rodriguez on a Nebraska highway for a shoulder violation. Struble checked the license, ran warrants, issued a warning, returned all documents. The stop's legal mission was complete. Then he asked Rodriguez to wait for a dog sniff. Rodriguez refused. The officer made him wait anyway. 7 minutes later, the dog alerted. Methamphetamine was found and federal charges followed. The Supreme Court ruled 6-3 that once the purpose of a stop is completed, every additional second of detention without new reasonable suspicion is unconstitutional. The phrase Rodriguez gives you is simple. Am I free to leave? That question is a legal trigger. When you ask it, the officer must either release you, articulate a new reason to keep you, or detain you without constitutional justification, which makes every piece of evidence gathered after that moment potentially suppressible. Officer says his partner just wants to run the dog around real quick. You say, "Am I free to leave?" Officer says, "Just a moment." You say, "I do not consent to any searches." Am I free to leave? Officer stalls. You ask again. Calm. Polite. Firm. You ask it until you get a clear yes or a lawful reason you are still being held. Bottom line, once the ticket is in your hand, the stop is constitutionally over. Ask if you are free to leave, and do not stop asking. Now for the most dangerous mistake in this entire video. The one that feels harmless in the moment. The consent collapse. You are stopped. There is nothing illegal anywhere in your car. The officer finishes everything, then asks in the most casual tone possible if he can take a quick look inside. You think, "I have nothing to hide," so you say sure. One word. Your Fourth Amendment protection is gone. That case is Schneckloth versus Bustamante, decided in 1973. Officers stopped a car in California with no license. One officer asked to search. A passenger agreed and helped open the trunk. Stolen checks were found inside. The conviction was challenged because nobody had told the passenger he could refuse. The Supreme Court ruled that consent to a search is fully valid even if the officer never told you that you had the right to refuse. You do not need to know your rights exist for giving them up to count against you. You said yes. Protection gone. This is the gap law enforcement is trained to exploit. After a routine stop, after documents are returned, after rapport is built and the mood is friendly, the officer asks casually, "You mind if I take a quick look?" That phrasing is deliberate. It is designed to sound like a small, informal request when it is actually you surrendering constitutional protection. Most drivers do not know they can say no. The only phrase that protects you is, "I do not consent to any searches." Not, "I have nothing to hide." Not, "I guess, if you have to." The moment any ambiguity enters your response, Schneckloth is working against you. Officer asks to take a quick look. You say, "I do not consent to any searches." Officer says it will only take a second. You say, "I do not consent to any searches." Officer says nothing to hide, right? Let us get you home faster. You say, "I respect that you are doing your job. I do not consent to any searches." Stay calm. Stay firm. Stay polite. Bottom line, you said yes, and your Fourth Amendment is gone. The only answer that preserves your protection is "I do not consent to any searches." 5 rulings. 4 phrases. This is the complete constitutional playbook for any traffic stop in America. Repeat each phrase 3 times right now, so your brain stores it under pressure. The first phrase. The moment questioning starts beyond your license and registration, I invoke my Fifth Amendment right to remain silent. This covers Salinas and Birdmere. The explicit invocation that creates protection from the first question at any stop. The second phrase. The moment the officer signals he wants to search anything, I do not consent to any searches. This reverses Schneckloth. You do not need to be told you can say no for saying yes to be binding. So say no. Say it clearly. The third phrase. The moment the ticket is done and the stop is extending, am I free to leave? This is Rodriguez. It forces the officer's hand and creates the legal record that determines whether continued detention is consensual or compelled. The fourth phrase. The moment the conversation moves toward anything criminal, I want an attorney. You do not need to be under arrest. You do not need a Miranda warning to have been read. Invoke your right to counsel at any point. Those words end the interrogation. Officer asks where you are coming from. I invoke my Fifth Amendment right to remain silent. Officer asks to search your car. I do not consent to any searches. Ticket is done, and the stop keeps going. Am I free to leave? Stop escalates toward criminal territory. I want an attorney. Write these down. Put them in your phone. Print a card and put it in your glove box. You will not have time to search for anything when there are red and blue lights flashing behind you on the highway. Now a word on how state law modifies all of this. The federal Constitution is the floor. Every state can build on top of it, but cannot go below it. On identification, every state requires your driver's license, registration, and proof of insurance. Hand them over without hesitation. Beyond that, 26 states have stop and identify statutes that require you to provide your name during a lawful detention. In Nevada, you must state your full name. In Indiana, refusing to identify yourself during a lawful stop is a Class C misdemeanor. In California, since January 2024, Assembly Bill 2773 requires officers to state the reason for the stop before asking any other questions, a protection that Texas and Ohio do not have. On searches, in Colorado and Maryland, the smell of marijuana alone is no longer probable cause since legalization. In Texas and Ohio, officers can still argue odor establishes probable cause. Know the rules specific to your state. The first 30 seconds of any stop are the most critical. Here is the safety protocol that protects everyone involved. The moment you see the lights, pull over immediately using your turn signal. If possible, stop in a well-lit area. Turn on your dome light at night. Turn off the engine. Put both hands on the steering wheel where they are fully visible. Lock your doors. Roll your window down only 2 to 4 inches. Before reaching for anything, announce every movement out loud. My license is in my glove box. I am reaching for it now. Every movement in those first 30 seconds is being evaluated on body cam. What you do with your hands, how quickly you reach, whether you appear calm or agitated. All of it shapes the officer's narrative before a single word is spoken in court. If ordered to exit the vehicle, comply. The Supreme Court established in Pennsylvania v. Mims that officers can order this for safety reasons. Before you step out, say clearly, I am complying under protest. I do not consent to any searches. Those words document that your compliance was compelled, not voluntary. Stay calm. Stay respectful. Be polite without being talkative. Your tone matters as much as the exact words you use. Hostility hurts you. Excessive friendliness can trap you. Calm and firm is the only setting that serves you legally. Here is what you now know. 5 Supreme Court rulings rewrote the rules of every traffic stop in America, and not knowing them does not shield you from them. Salinas v. Texas. Silence alone is not a Fifth Amendment invocation. Say the words or your silence becomes the prosecution's evidence. Hayen v. North Carolina. An officer's reasonable legal mistake does not make a stop unconstitutional. Win that argument in court with an attorney, not at the window. Birdmere versus McCarty. Your Fifth Amendment rights apply from the very first question at any traffic stop, not from the moment of arrest. Rodriguez versus United States. Once the ticket is in your hand, the stop is constitutionally over. Ask if you are free to leave, and keep asking. Schneckloth versus Bustamante. You can refuse a search whether or not anyone tells you that you can. And once you say yes, that protection is gone. Say the 4 phrases from memory right now. I invoke my Fifth Amendment right to remain silent. I do not consent to any searches. Am I free to leave? I want an attorney. Practice them tonight. Say them out loud in your car before your next drive. Your ability to say them calmly, clearly, and firmly when a uniformed officer is standing at your window is the only thing that makes everything in this video actual protection rather than just information you once read. This is educational content only. For guidance specific to your situation, consult a licensed attorney in your jurisdiction. If this video gave you legal knowledge you did not have before you clicked it, subscribe to this channel right now. We are releasing more videos on your rights, how to use them, and the exact laws that determine what happens to you at a traffic stop, in a police encounter, and in a courtroom. Hit subscribe, turn on notifications, and share this with every driver you know. Their rights do not protect them if they do not know what those rights actually are. The next video already on screen covers how these constitutional protections layer on top of each other during a single stop, and where most legal defenses collapse before they ever reach trial. Click it now. Drop a comment below telling me where you are watching from and what made you click this video. And share it with one person who drives. Because you are not helpless at a traffic stop. You are protected. You just have to know the words.